Hi, everyone. Thank you for being here, and thank you for being so prompt. So welcome to our first Human Rights in Practice event of the spring semester, Ensuring Business Accountability for Human Rights Violations. And as you might know, the Human Rights in Practice event series is organized by the International Human Rights Clinic and SICL, the Center for International and Comparative Law. We also have several co-sponsors today, so I wanted to mention those. The Duke Human Rights Center at the Franklin Humanities Institute, and then several student groups here, so the Human Rights Law Society, the International Law Society, the Environmental Law Society, and the Food Law Society. So thank you to all our co-sponsors. I'm going to now introduce our two speakers, and we're so happy to have them here with us in person in particular. So first we have Rachel Chambers, who is Assistant Professor of Business Law at the University of Connecticut Business School. And her areas of expertise include business and human rights, corporate social responsibility, international and comparative law, tort law, corporate law, employment, and discrimination law. Dr. Chambers' research focuses on business and human rights, including corporate accountability mechanisms, such as transnational tort litigation, and laws mandating human rights disclosure and due diligence by corporations. And prior to joining the UConn School of Business faculty, Dr. Chambers was a postdoctoral research associate at UConn in a collaboration between the Office of the Vice Provost for Research, the School of Business, and the Human Rights Institute. Dr. Chambers is also co-director of the Teaching Business and Human Rights Forum, a body comprising 350 teachers of business and human rights from 140 different countries. And Dr. Chambers is actively engaged in business and human rights pedagogy. Just to mention a few of her recent publications that may be of particular interest to all of you, they include Reimagining Corporate Accountability, Going Beyond Human Rights Due Diligence, published in 2022, and a second one, United States Potential Paths Forward After the Demise of the Alien Tort Statute. This is just two among a very, very long list of publications. We'll then hear from Terry Collinsworth, founder and executive director of International Rights Advocates, which he established in 2007 and where he focuses on international human rights litigation. The vision of International Rights Advocates is, quote, a world free of slave labor and other crimes against humanity, where those who have experienced human rights abuses in global supply chains have access to justice. Terry Collingsworth has litigated cases globally and uses his legal experience to bring international networks, including lawyers, educators, and human rights activists together, to work together on strategic litigation, public policy, consumer campaigns, targeted actions, and other steps. And importantly and happily, Terry attended Duke Law School and has taught at various law schools and published in a range of different publications on human rights issues. So again, a warm welcome to both Dr. Chambers and Terry Collinsworth. So they'll each speak with PowerPoints, and then we'll open it up for questions. So please, as you listen, think of questions or reflections you'd like to share with us with them at the end. Thank you all.
Thank you so much for that warm introduction. It's such a pleasure to be here today and to speak to you about this subject, and obviously to share my platform with Terry. It's been such a lovely invitation to take up, and I'm very grateful to Duke Law's International Human Rights Clinic and obviously the Center for International and Comparative Law for hosting me, so thank you. So today, I'm going to let Terry speak about some of the cases and to bring some of what I'm going to talk about in terms of the laws really to life. And I'm going to talk about some research I've conducted. The name of the paper is obviously on the slide here, Human Rights Disclosure and Due Diligence Laws, the role of regulatory oversight, ensuring corporate accountability. But the common theme, of course, that we're both talking about is business and human rights, and within that, corporate accountability for human rights violations. Just real quick, because this is obviously Duke Law's Human Rights Practice Event Series. You know, I'm a practitioner, that's my background. I practiced in law in the United Kingdom for 10 years as a barrister, and I'm always looking at the practical application of my research now that I find myself in academia. So Just a few words of introduction about the paper. So when we talk about business and human rights, this is a field that was characterized very much by voluntarism, and that may be what you think of, first of all, voluntary standards, principles, CSR, but it's an increasingly legalized field, particularly in Europe, which is obviously where I come from, and as a comparativist, a dimension I'm obviously going to bring to you today. So in terms of these laws, the first wave that we saw, as I say on the slide, were primarily laws concentrating on disclosure or transparency, so companies reporting on their human rights impacts. Partly in response to what's been seen as flawed human rights reporting practices and what's been documented as such over the years that these laws have been in place. A second wave is now on the move, requiring companies to conduct human rights due diligence. And I'll talk in a moment a little bit more about what that is. But just suffice to say, by way of introduction, that in the business and human rights space, I think we see these human rights due diligence laws as this kind of beacon of hope, that this is going to be the future. And in some ways, what I'm doing with my research is kind of applying some brakes and asking some questions. And obviously, with my corporate accountability hat on, asking about robust implementation and enforcement. What does that look like? So before I get to the paper, I just wanted to connect my research to practice, in keeping with the nature of this series. So these examples of practice, this is not my own practice, but this is how we see the rubber hitting the road in terms of human rights due diligence laws. We have such a law in place in France. I'll talk about that. But here we have civil society organizations in France, Friends of the Earth, Sherpa, and others, working on corporate accountability and using the law in question as the lever to do so. So this is the practice, right now. And these, one of these screenshots is from the 23rd of January this year. So this is very current. But just also in terms of practice and my research, what I hope to do with it is sort of not just see it sitting on the pages of Chicago Journal of International Law in the case of this piece, but to bring it alive, for example, by being interviewed by advocacy organization Rights Colab to talk about what we mean by this and what we hope to achieve with what we've been researching. I also work with civil society organizations in the UK, largely actually, and that's where, for whom I did this report, looking at how in the UK we could have a regulator to enforce a proposed law on human rights due diligence. And then at the international level, working with organizations like the Office for the UN High Commissioner for Human Rights, thinking again, look, we're having these laws are being enacted, how can we actually ensure that they're enforced? And what does enforcement look like? So working at that level. So turning to the content of the paper, I want to just acknowledge, of course, my co-author, Anil Yilmaz-Vastalis, from the University of Essex in the UK, which is where I did my PhD, so long friend and collaborator. It was published in 2021. So actually, this area moves fast. I've talked about due diligence laws, and you'll see in a moment on the slide, some of these have been enacted since we wrote. We knew they were coming down the pipeline, but this is a fast-moving field. So in the paper, we obviously outline and compare both disclosure and due diligence laws, thinking about why they were enacted, what they contain by way of requirements or obligations on companies, and of course, the institutional arrangements supporting them. Particularly highlighting, as I say on the slide, their potential contribution to corporate accountability, but also some of the drawbacks, the limitations, as I alluded to before. And then we conclude by looking at enforcement, and focusing on whether there is any state-based regulatory oversight or whether we're largely looking to the market for enforcement, which is, the model here. So something we very much see when it comes to these kinds of laws. So I break the laws down into two different types, general and then targeted. General means that they address the full suite, the full range of human rights. They're not targeted at a specific issue like modern slavery or conflict minerals. So you'll see some of these feature in the paper if you've had a chance to look at it, and some of them are new. For example, the Norwegian Act of 2021 is relatively new. We also have a forthcoming EU Corporate Sustainability Due Diligence Directive, i.e. bringing this kind of law across the member states of the European Union. We expect to see that come out this year or next. So a few words about these laws. Obviously, disclosure, that's telling companies to disclose, to report on their human rights impacts. But what about this due diligence? I said I'd say something really quickly about it. And the French law on the corporate duty vigilance I mentioned before, as the only law currently in force, and having companies already having to do the work under it. It's kind of our best example, our working example. So what does it mean? What does human rights due diligence mean? Under the French law, it requires companies to create and implement what's called a vigilance plan, aimed at identifying and preventing human rights violations, both in their domestic operations there in France, but also in their international operations, and those associated with subsidiaries and supply chain, so really across the reach. The plan must set out the steps that the company will take to detect these risks and to prevent serious human rights violations or also environmental violations, including mapping out and analyzing the risks and putting measures in place. I mean, this is a really big part. Putting measures in place to mitigate the risks and address negative impacts, including things like alert mechanisms, monitoring schemes. So it's in case it's not, really obvious, this is a big step forward from reporting laws. It's an obligation of conduct, an obligation that companies actually have to do something as opposed to reporting out on it. When it comes to these targeted laws I mentioned before, the first 4 on this slide obviously relates specifically to issues of modern slavery, forced labor, etc. And the last obviously is conflict minerals. The second also conflict minerals. These are largely disclosure laws with the exception of the conflict minerals regulation, which has some due diligence built in. I'm going to speak less about these today, just to touch on them briefly in terms of their oversight and to kind of encapsulate it. It's light touch, extremely light touch. So, for example, you'll see how I've got mention of the Californian Act, the Australian Act, and the UK Act. Between them, they have sort of slightly different arrangements in place for state-based oversight. But, for example, a power to seek injunctions, let's say because a company hasn't complied, rarely used, if ever, in each of these jurisdictions, California, England, Wales, and Australia. We don't even have things like a definitive list of which companies are required to report. And certainly only in Australia do we have a repository. So actually a place you could go to go find those reports as someone on the outside trying to understand, has a company done what it's supposed to be doing here? So as I say, oversight, intentionally delegated to the market, consumers, investors, civil society, journalists, whoever it may be, but not the state. Again, briefly to touch on this acronym, the EU Non-Financial Reporting Directive, which is, EU-wide, so has been adopted throughout the member states of the European Union. It actually dates back to 2014, so it's been around for a few years, and is shortly to be superseded in a big wave of European legislation in this field, covering not just reporting, but also due diligence and looking at green finance, many other aspects. Again, I don't want to dwell on it too much today, but suffice to say, non-financial reporting, as the name probably kind of alludes to, sits next to or as part of financial reporting. So this is companies as part of their annual reports also including a piece around their human rights, environmental, etc. impacts. And but in terms of oversight, which is obviously what I'm looking at here, who's looking at this? Who's checking this? The Non-Financial Reporting Directive leaves it very much up to the member states to decide who's going to do this. There's very limited requirements in the directive for the member states to obviously kind of put this into place through their law. For them to, they can do some kind of check that the report's actually been done. But if they want to do any more, check about whether it's actually, telling the truth, whether it contains what it's supposed to contain. That's really only done by one state, particularly well on the slide, you'll see Denmark. And typically we're looking at financial regulators. So those that will be looking at the financial reports, then also going to look at this as well. In the UK, it's the Financial Reporting Council. It has no expertise in this field. It's a Financial Reporting Council. And then again, I don't want to dwell too long on the conflict minerals regulation, but suffice to say, these do build in oversight, regulatory oversight. They call it a competent authority. You can go to the EU and look at who these authorities are and what they're supposed to be doing. But the bottom line is we have, some small system of checks. Is the due diligence being done? But no fines, for example. So limited sanctions, if any sanctions at all. But turning to, what I really want to touch on in a little more detail today, French duty of vigilance. What we have here is a slightly different arrangement in keeping with the tradition in France where regulators are not such a strong part of the administrative infrastructure. And so we see very much reliance here on the courts for oversight. And, as I say on the slide, if a company fails to comply with the duty of vigilance obligations, what's described as the person with a legitimate interest, non-governmental organizations, trade unions, etc., individuals affected, can first give official notice of their concern to the company, so they can notify the company of what they understand to be the deficits. And then if within 3 months they're not satisfied with the response or there's no response, then there's the ability to turn to the courts. There's also a civil liability provision built into this law, which allows individuals to sue companies if harm occurs, which could have been prevented had that vigilance plan been properly developed and implemented. This is very tough. We haven't seen this occur in practice. It's tough to establish causation here. And so it's really the top one I'm going to talk about briefly in a moment. But just before I do, and actually before I turn to Germany, I just wanted to mention, although we have what looks like at least some oversight, albeit through the courts rather than through a regulator, for example, there are some real drawbacks here, one of which kind of is the fact that we're talking about the courts. On one hand, we see cases already coming before the courts, so this is a process which is being utilized. That slide I showed you right at the beginning of practice did actually have one of the court cases on there. But what we've seen is technical battles occurring in the French courts about, for example, which type of court should hear the case, and generally a feeling that there is needed to be some kind of regulatory oversight. There's actually been a report looking into this, whether the French administration could look at, for example, some oversight of how the law is being implemented, whether provisions of the law need to be clarified. And I'll talk in a moment about one case briefly to give you an illustration of what we're talking about. But kind of picture of oversight, two new laws, the German law and the Norwegian law on the next slide, both actually do have their due diligence laws, like the French law, requiring companies to conduct due diligence, and each has actually established a regulator. In the case of Germany, this falls within the Economic Ministry, the Federal Office for Economic Affairs and Export Control, raising potential concerns about where the interests lie and how good this entity will be as a regulator. But it has some strong tools up its sleeve by way of fines, etc., and the ability to curtail procurement, so to stop these companies, if they are breaching the law, from supplying to the German federal government. And then on the Norwegian side, the consumer agency in Norway, of course, being the regulator, again with powers to push for companies if they aren't complying, ask powers to push them to do more. My last couple of slides that I'm going to share with you today, one of them is an example of a lawsuit. This actually is one of the pictures that featured on my Human Rights in Practice slide at the beginning. And just suffice to say that this case has now been going on for 3 years, but we do see Friends of the Earth and Ugandan non-governmental organizations using the duty of vigilance law in France to try and enforce these human rights standards. They're saying that Total, which is obviously a French oil company, that its vigilance plan didn't identify some major human rights violations occurring in Uganda, and what were really huge environmental impacts, again, of the same oil project. And so they're asking not just that the vigilance plan be updated, but also that the company take proper steps to mitigate. Remember, I said to you, this is the kick of the law. It's not just about what you write in the plan, it's actually taking steps to do this. So last but not least, for me now, I'm just going to share with you a list of my wish list for regulatory oversight. This, by the way, does not exist anywhere in the world. I don't have a template to show you. I'm just saying, this is what we need if we're going to make these laws work. Bottom, but most important, business and human rights subject matter expertise. understanding what it is to do well in this field, how companies should be doing their reporting and due diligence, and the issues at stake. But also, obviously, the ability to receive complaints, to sample reports and due diligence efforts, and feedback to companies. I'll finish there. I've got a slide on the US, but you can ask me that in questions. Just wanted to highlight that I've put some resources on my last slide, and that the slides will be shared with you if you're interested to follow the links. Both the article and some other resources are there. Thanks so much for your attention, guys.
Hi, everybody. I'm Terry Collingsworth with International Rights Advocates, and I'm a proud Duke graduate, and I can say that when I studied here many years ago, before any of you were born, international law and international human rights law was pretty much UN or governmental-based regulation that really was just wishing that things were better. And we've made a lot of progress since then, and we have a lot of ways to go, but I'm saying that you're jumping in at about the right time. We have some tools now. We need people who are willing to use those tools and really focus their work on getting companies to actually comply with standards. I'm going to first show you some pictures of some of the horrific situations we face, and I think that's a good way to really think about this. Is here's a reality. What can we do about that reality with the tools that we have? So one of the cases we have pending against Apple, Alphabet, Dell, Microsoft, and Tesla is that they are using cobalt mined in the Democratic Republic of Congo, the DRC, in part by children, very young children. And the children aren't just working, they're regularly being killed and maimed in tunnel collapses because there's no support, there's no protective equipment, there's no training, there's nothing. These kids just show up, they work for about $1 a day, and they regularly get killed. This is what a tunnel looks like. This is all these fancy gadgets that you have, all your iPhones, all your Apples, all your EVs. The cobalt is coming out of that hole. And this kid is going to climb in that hole. I interviewed a bunch of kids that lived after a tunnel collapse. Some of them are my clients. And they all said, we know that tunnel is going to collapse. They all do. Is it going to happen while I'm in it? So can you imagine being a child and the only way you can eat is to climb in that hole, but you know that it could collapse and kill you or cripple you for life. This is another dangerous job, carrying the big sacks of cobalt down the mountain. I have two kids who, the tunnel below them, the ceiling collapsed and they fell into it and were severely injured. There we go. This is like a starter job for young kids. They let them wash the cobalt off, and then eventually they work their way up the mountain and climb into tunnels. Another kid about to climb in. This guy's helpfully loading up like a 7-year-old with a big sack of cobalt. These kids are probably 6, 7 years old. It's just another picture of an ominous tunnel. 70% of the world's cobalt comes from the DRC. So again, none of the companies deny that their cobalt is coming from the DRC and that some of it is mined under these conditions. When we sued these companies, the only thing that we can detect that they've done so far is that they put up some really strongly worded policies on their websites. That's it. That's the only thing. I have been back. My people are there right now in the DRC just looking for signs of hope. Are they going to do anything with their trillions of dollars to fix this? Not until we make them. That's kind of my end of corporate social responsibility. They won't do it till you make them. Now I'm going to show you a few pictures of child slavery in cocoa harvesting, an issue that I've been working on for 20-some years, really. So in cocoa, the U.S. Department of Labor issued a report in 2020. So it's not just some crazy left-wing organization. The U.S. Department of Labor, they counted, they hired the University of Chicago, big research team went over there. They estimate 1.58 million children today are harvesting cocoa in Cote d'Ivoire and Ghana. And they're working like this. It's not like after school. They're working all day long. This is dangerous. You're going to see they're using sharp tools. They're applying pesticides and herbicides. And all of it is illegal under the norms that we've all agreed to. Primarily, International Labor Organization Convention 182, which all countries of the world, even the U.S. signed this one, that outlaws the worst forms of child labor, and that includes heavy lifting, applying chemicals, and using sharp instruments. I just interviewed these kids. They were trafficked from Burkina Faso, and they estimated he's about 13 and 15. They didn't really know their birthdays. And again, the tech companies and the chocolate companies, when you confront them, they all are playing from the same corporate playbook as far as I can tell. So they start off with, we have no control over our suppliers. We just buy cobalt or cocoa, and we don't know how it's produced, and we're strongly opposed to child labor. In fact, the cocoa companies in 2001 promised the rest of us that they were going to come together and stop using child labor. They signed a protocol, the Harkin-Engel Protocol, in 2001, 22 years ago, admitting that there's forced child labor and other worse forms of child labor in their supply chain, and they're going to stop it. Since then, they've reverted to the we just buy cocoa. I just was in court with them a couple of weeks ago, and that's the position of their lawyers. We have no control over what's going on. It's not us. We're just buying the cocoa. How do you deal with people like that? Before we get into how we deal with people like that, I just think it's very important to consider just the chasm of values, that we all agree that child slavery is wrong. We all agree that using children to work under very dangerous conditions where they get killed and maimed is wrong. All of these companies have policies that say it's wrong. So we're not coming to them and saying, I've got a great idea. Why don't you stop using child labor because it's bad? They already say they're doing it, but they're just not. And that's really what our job is to make them comply with their own commitments to apply values and standards that they've already agreed to, as have the rest of the world. So here's some options for legal action. I'll just quickly talk about them. First, we used to have a wonderful option called the Alien Tort Statute, and the site is there. We used it very successfully. Our first case was against Unical, Union Oil of California, which is now Chevron owned, and Total. Together they were building a pipeline in Burma using forced labor. They had the military round up villagers, and then they put the villagers to work at gunpoint. We settled that case on the eve of trial, but we had a real tool here. So what happened? Corporate America, the U.S. Chamber of Commerce, the U.S. Council for International Business, the National Association of Manufacturers, every time we had a case, they started filing amicus briefs against us, urging the court to put a halt to this nonsense that multinational corporations could be held accountable in court for what they're doing in their far-flung empires. So the Supreme Court obliged. They little by little whittled away at what the statute would allow, and then they imposed on a 16-word statute some of the key originalists on the Supreme Court, Thomas, Alito, and Scalia at the time when he was alive. They imposed a extraterritorial jurisdiction test that is so complicated and many more words than the original 16 of the statute, and it has essentially now gutted the statute. In the case I've cited there, that's my case. We sued Nestle for child slavery, and the Ninth Circuit resoundingly ruled in our favor. And then we went to the Supreme Court, and when they accepted cert, we knew we were in some trouble. So they applied this extraterritorial standard, which used to be that the claims had to touch and concern the territory of the United States. And then they explained how that might be. In Nestle, they said it had to be the focus. The U.S. territory had to be the focus of the claims. So after this decision, we pretty much determined that the only way we could hold Nestle liable for child slavery under this statute is if they kidnapped children from the United States and took them to Cote d'Ivoire and put them to work. That's what we're left with. Now we put out with a lot of other groups, Human Rights Watch, the AFL-CIO, we have a legislative fix that simply adds to the text of the ATS that it is extraterritorial, and we explain what that means. Even when the Congress was completely controlled by Democrats, it didn't make their short list of things to do that term. So it's sitting on someone's desk, but it's easy to fix. We just need political will to get it done. So getting down to the next option, we have something called the Trafficking Victims Protection Reauthorization Act. Now we're using this a lot. It only outlaws trafficking and forced labor, so that unlike the Alien Tort Statute, which covered all law of nations violations that were universal, obligatory, and mandatory, the trafficking statute only outlaws trafficking and forced labor. But unfortunately, there's plenty of that going on. So currently, we have cases against the tech companies who are using forced child labor and trafficked child labor in their supply chains in the DRC. And we have a case pending against the big 8 chocolate companies, Nestle, Cargill, Mars, Hershey, Berry, Callebaut, Mondelez, probably forgetting one, but that case is also pending. In the Apple case, we just had an argument in the DC Circuit Court of Appeals on December 8th that really is going to tell us what's left of or whether the TVPRA is viable. Every single issue, really, of how you would sue a company is in play in that case, and the DC Circuit will issue a decision in the coming months. So there's a lot riding on that. I think we won. I think our argument went very well, but we'll see. And then we'll see if the Supreme Court decides to completely gut that statute as well. So those are the 2 key federal laws that we're using, and it's precarious because the laws can be interpreted by very conservative courts and slam the door on our efforts. I don't think they're going to really gut the trafficking statute because it outlaws sex trafficking, and a lot of Republicans voted for it because of that issue, that they didn't really think that it might also go get Apple and Tesla, but the statute is needed to prevent and remedy sex trafficking also in the global economy. Some other laws we use, the common law. We always now, back when we knew that the Alien Tort Statute was on one leg, we started adding common law claims for typically unjust enrichment, negligent supervision, and emotional distress. In fact, and wrongful death. I'm not sure why that's not there. In fact, I have a case, my oldest case, I filed against ExxonMobil in 2001 for using the Indonesian military in Aceh to protect their natural gas drilling facilities. And we sued them under the Alien Tort Statute. We also used the common law. This case is 22 years old because during the Bush-Cheney years, the administration put a hold on it because 9/11 had just happened. And they went to the court and said that this case offended the government of Indonesia, that Indonesia was an important Islamic partner in the fight against terror after 9/11, and that we didn't want them to be angry with the U.S. government. So They put a hold on the case for about 7 years, and we finally got out of that hold when the administration changed. And now we recently won a summary judgment ruling, and the court has set trial for May 24th, 2023. So in a few months, we are finally taking Exxon to trial. And just yesterday, our 11 plaintiffs, who are ladies who had their husbands tortured and killed by the Indonesian forces working for Exxon, they all got their visas, which we thought was a miracle. We pulled out all the stops, we hired an expert, we made sure that we had everything perfect, and then we got the number of the top people over there and called them and made them feel a little personal responsibility, and they granted the visas. So this is going to be fun. But that case is going to trial on just wrongful death now because the ATS claims were knocked out by the two rulings the Supreme Court gave us. We also use, with limited success so far, it's called the Tariff Act of 1930, but it allows anyone to petition Customs and Border Protection to ban the importation of a product made with forced labor. So recently, people have banned the importation of tobacco from Malawi, latex gloves coming from Malaysia, and that's a case that I have. We've sued some of the companies involved on behalf of former trafficked and forced laborers. But we have a cocoa case based on the U.S. Department of Labor's findings of the extensive use of child labor and forced child labor in Cote d'Ivoire. We said, you ought to ban the importation of that chocolate. We filed that 3 years ago, and it's still pending. That's what they can do. That's what's wrong with that law, is there's no deadline. It is completely administrative. So once you file your petition, they won't tell you a thing, and they can sit on it for a very long time. We're going to sue them under the Administrative Procedure Act for non-action. That's about the only thing you can do to challenge agency action these days, is to say, we can't tell you what to decide, but we can tell you you must decide. You have to take action under the statutory authority granted you by Congress. So that might provoke them to deny our petition, but I think it's better to flush that out in the open than just let it sit there. And then we do consumer cases. We just won a case against Nestle. We won the motion to dismiss. We allege that they're misleading consumers by claiming that they're working to stop child labor or that they don't have child labor in their product, when in fact they do, and when in fact they're telling courts that they're not doing a thing. They have no responsibility at all. So we got a district court in Los Angeles to find that we survived the motion to dismiss. We had a credible claim, and now we're going into discovery against Nestle. I will add that we're about to bring our first case under the French due diligence law. We're working with Sherpa, one of the organizations mentioned, that we're going to go after, I can't name them publicly yet, a couple of supermarket chains in France that are selling the chocolate of all these companies, and they're not disclosing that it's made by child labor, or even really that there's a child labor problem. So we're finishing that up, and we have some good lawyers in France working with us. And that's exciting to me because these collaborations are really what we're going to end up winning with, because some countries have better laws, some people have better access to facts, some people have more resources. As soon as we all come together and work together, then we have a chance to actually win. I'm just going to very quickly, talk about non-legal paths to success. So I think the third one down, strong public campaign, is really where the hope and action is, that we need more consumers to vote with their pocketbooks, to care enough to tell the companies you're not going to buy their chocolate or their $100,000 Tesla unless the company can assure you that it's not made with child labor or there's other serious human rights violations involved in its production. So if you go on our website, you'll see that there's a way to click on both all the cocoa companies and all the cobalt or the tech companies that sends them an email directly where you could say, I'm not going to buy any more of your stuff until you stop doing whatever that particular company is doing. But I think that enough people give those messages and take the couple of minutes, it's likely that the companies will take notice. Some other things we're doing is working with governments to have divestment bills. We just worked with New York State to have their pension plan. There's a pending law, not yet passed, that will require their pension plan to divest from all tech companies that cannot show with independent verification that their cobalt supply chain does not include child labor. We're working with California on that, and we're hoping that these initial bills will cause other states to join in. We help with shareholder resolutions where stockholders of Apple or Tesla can go to the shareholder meetings and demand as a shareholder that they take specific action. And we're also working with many other groups to just try to raise funds from foundations and individuals to help the kids that are injured. They need help right now. They can't wait for another 10 years for us to win our case if the Supreme Court doesn't kill it. So there's a lot of need for direct action on the ground in these kinds of places where children are openly abused and their own governments are doing nothing to help them. Just if you want to follow up with the companies, the website, there's very good information about each of the cases. Just go to our website, internationalrightsadvocates.org. I'll stop there so we have a little room for questions, but I hope that you all will join the fight in some way and do whatever you can to stop this abuse that is going on in open space in our global economy.
Well, thank you both so much, and thank you for being timely so that we do have time for questions or comments from all of you, so looking forward to that. Noah?
Thank you so much for the wonderful presentation. I wanted to ask about the possibility of a pension product. Terry, you mentioned that some versions of the law should be used, but is there a chance that there will become due diligence agents where companies can incorporate such that they aren't subject to certain regulations? And
Well, thank you. I think the United States is trying to lead the way in becoming the bottom of due diligence. And if you go to the Doe versus Nestle case at the Supreme Court level and read the Chamber of Commerce brief and the U.S. International Council of Business briefs, that's exactly what they're saying. They're saying this is bad for business. We can't have this. Regulation of the global economy, that's crazy talk. I mean, they're adamant that this is just wrong to subject their capitalism to any kind of regulation. So I think we are probably leading the race to the bottom. The Europeans, as Rachel mentioned, are really moving forward with due diligence laws, but I find that most of them are a little tedious. Like, it'll take forever to enforce one of these things, and I'm not sure if anyone's going to streamline that, but I'll not put words in Rachel's mouth.
I think it's a really good question. Thank you. I think, I agree that, obviously here in the US, like a federal human rights due diligence law seems fanciful. But we do have, some of these laws will bite US companies, not the French law, which is actually limited to quite just a limited number of French companies, but the German law, the EU Directive, which is not in place just yet, they actually reach companies that operate in the market. So if they sell or, if they have a presence of a certain size within the European market. So it's going, forward-thinking businesses should see this on the horizon. And there's even arguments by, I would also just, hopefully forward-thinking businesses that there's, the playing field should be leveled for all, and that this should be actually a reason why either there should be a law here or there should be a UN treaty, which is also being negotiated, but again, also feels like something that's, a bit of a distant prospect. Obviously what you want is to see standards elevate around the globe and not race to the bottom. But obviously the concern is that, yes, you will have tighter regulations, for example, in Europe, and then, yes, a get out here.
Yeah, a brief funny story. So when we first sued Exxon, before they got to know me better, Exxon's outside counsel agreed to a discussion in Congress before a subcommittee with me and him about this case. And he stood up and said something like, if you chase Exxon out of Indonesia, the Chinese are going to come in, and then you just never know what's going to happen then. And I stood up and said, no, I want you all to be clear. What we say Exxon did is that they hired a brutal military force that tortured and killed people, raped their women, and left the village in ashes. So what do we think the Chinese might do? But that's the kind of mentality. That's one of the hot buttons. Capitalism, free and fair in the United States of America. And that if we don't do it, the Chinese will. They always play that Chinese card when, in fact, the Chinese are really pretty strategic outside of China in terms of how their businesses operate because they're fully aware that the magnifying glass is on them. One of the Chinese mining companies in the DRC, Huayu, it's actually doing way better than the Swiss company Glencore in trying to make some progress.
You mentioned how the Chamber of Commerce and other organizations are concerned or are arguing that these laws are bad for business and hurting American corporations. I was just wondering if there's any kind of flip side to that argument where a lot of production isn't done anymore in the U.S. because we have child labor laws or other such laws that some of these other countries don't have. And I recognize that cobalt, you can't move where the cobalt is located, but for other manufacturing concerns, is there an argument that that if we're actually prosecuting these companies for just outsourcing their labor in horrible conditions that aren't allowed in the U.S., that if you actually prosecute them, they'll start bringing their production back to the U.S.?
I'm going to let you answer that.
Okay.
Has that argument been made?
Well, the argument has been made, but I think that ship has really sailed. That all of the countries that are doing complex manufacturing probably all have very similar laws. So that floor is pretty stable, and that the companies seem to be making decisions based on different factors now, including supply chain distances and the cost of shipping and so on. It used to be absolutely true that the U.S. laws drove the NAFTA agreement and drove all that manufacturing to Mexico, but Mexico's catching up, and that's really the injustice of it all, is that when I chased Nike around the world. Nike used to make shoes in Oregon. Then they went to Korea, and then Thailand, Taiwan, then they went to Indonesia, then they went to Bangladesh and China. And each time one of those countries, let's say Korea, finally started making progress, like their workers were making a decent wage, the conditions of health and safety got a little bit better, then Nike would say, so long, buddy, and they would go to the next place where they could turn back the clock another 100 years and start all over with abuse. So that's kind of near the end. There's not many places left on Earth where you could go set up a factory and lash children to the machines and make them work. Bangladesh was kind of the end of the world, and they're making some progress now. So I really think that the issue is just they should be accountable wherever they are.
Olivia, Madeline, and Cameron.
Thank you so much for speaking to us earlier in the talk today. You mentioned some non-legal paths, and one of them was raising funds for the publications that the community is taking now. And it seems like that's something that should really fall on the corporations who are kind of doing this to the children. And so I wonder if under the due diligence laws or under something else that's considered as part of litigation or just having a separate requirement and aside funds for them.
Thank you. Certainly, in my experience, we have repeatedly offered to the cocoa companies and the tech companies that if they worked with us, that we could help set up programs that they could fund. and that would save everybody a lot of time and misery and help the children at the same time, then they could take credit for it. On our slide, which you all can have if you want, I have a website to an organization called Goodweave. They used to be called Rugmark. That's the only successful program that I'm aware of that has this cooperative model with the business itself. I was a founder of Rugmark, and I worked with Kailash Satyarthi, who then got the Nobel Prize, and I got a T-shirt. But this thing is functioning very well because we convinced the carpet companies, hand-knotted carpets made in South Asia. They were made by children. They were chained to looms. It was horrible when we first started looking at it. They got such a horrible reputation, people weren't buying the carpets at all. So we convinced a large number of carpet retailers that if you had a label that said Rugmark, now it says Goodweave, that would indicate that it was certified by us as having been child labor free, it would be very valuable. And in exchange, you had to pay, I think it was 1.75% as the importer, a tax that we put 100% of into a rehabilitation fund. This program is thriving. Go on their website now. I'm no longer affiliated with them, except as friends. But they have probably put 10, 15,000 former child slaves through schools, and they're thriving. So that's an excellent model. I have sat down with the cocoa companies, and I know that when we first sued them in the original Nestle case in 2006, I know from their SEC filings and just also estimates of projections, they've spent at least $100 million just on lawyers. We don't know what they spent on lobbyists. We don't know what they spent on public relations firms. But I can, every chance I get, I say, if you would have put that money into a fund when we first talked to you, we wouldn't be here talking now. We would have solved the problem. Those kids would be educated, but they didn't do it. Why? I don't know. I think that the problem is that if they feel that they accept responsibility for this one aspect, they're going to be responsible for everything. So they're just trying to slam that door shut and not take any steps towards owning what's in their supply chain. So we have to make them. I think that's now my mantra is they'll do whatever they can get away with until someone makes them stop.
Just really quickly, I know there's a couple of other questions, but I was going to say remediation is supposed to be part of human rights due diligence properly done. So there is this inbuilt piece around remedy, but where the potential challenge is how far down the supply chain the due diligence obligation exists. And this is something which has been, it varies according to the law in question, but there's some wriggle room there, I think is the best way to summarize it. But yeah. Thank you.
So we have Madeline, Cameron, anybody else? Okay, go ahead, Madeline.
Given what happened to Stephen Donziger, I was just wondering if you're worried something similar could happen to either of you or has something like that happened?
Sure. Well, I can say, first of all, Stephen is a friend of mine, and I have been recently advising him now that he's out of prison on some things that we're going to do that are going to be a lot of fun. Stephen is not bowed. Yeah, I've been sued. There's a pending suit against me for RICO and defamation by a coal company in Alabama that I caught using paramilitary groups in Colombia to protect their coal mines. And it's completely bogus, but it's a SLAPP suit, which means I've spent ungodly amounts of money defending myself and a lot of time. When we can't sue them for misuse of process because until we win the case, because they're in Alabama, which does not have an anti-SLAPP statute. So we probably will go on a couple more years before I can get back to them. But if we let them intimidate us, and Stephen Donziger will be the first person to say it, if we let them intimidate us and keep the human rights community from taking aggressive action in the face of known facts, then they win. And so we just have to take that as a cost of doing business.
Just to add to that, no, not personally, but I think it's a really important point to raise, not just in relation to Stephen Donziger, but also thinking about human rights defenders, people who speak out against companies not just here in the US, but around the world, particularly in places like Latin America. It's very dangerous to be that person. Global Witness accounts each year for the number of lives lost, and it's, quite staggering. So unfortunately, this is a real, a reality of this field. So it's a good question to raise.
And Greenpeace has been sued so many times
Yes.
under SLAPP suits. They wear it as a badge of honor, though. They win those cases, and they have the resources.
This is mostly for Mr. Collinsworth, but I have a separate personality as well. That's what we're going to do. When you identify like the non-labor pathway, one thing I didn't see up there was like making use of social media, especially in light of kind of some of the restrictions that the state push on and the stuff accountability. And I was just kind of thinking about, being part of like Gen Z, like these are something that TikTok that is be able to use have all this post on Twitter and then it's going to do this and it's not everyone like on the page. So like I'm just kind of thinking like why isn't that a larger part of getting the word out, especially if some of these things revolve around political will and change people.
Well, the main reason from my perspective is that I'm old. But we did, I agree with you that that's part of the public campaign. Public campaign includes social media. We did do some TikTok experiments. Actually, my daughter did. And we were, right, with no effort at all, we were getting 500,000 followers. And then TikTok itself introduced us to some people they called influencers, and they did some other ones on Coco that were really, really hit big. The problem is, okay, it takes time, and maybe I should hire just a social media person. But what we're seeing is that the result of that effort is just someone clicking like or whatever you do. It's not done anything. It's a phantom achievement to say 500,000 people liked your video on TikTok when not a thing happens after that. And the companies, they have social media experts. They know that, don't worry about this, it's just a passing fad. Now that's not to say that something could not go viral and really create a sensation. We haven't done that yet. But to answer your question in short form is we need to have a real careful look at what we could achieve with it and get some help doing it.
Yep, I agree. I was going to say, you have to treat it with care to a degree because, if all you do is like, then, and you think you've sort of helped take this issue forward, then perhaps, you need to do a bit more. But it's also really important to publicize. The reality is that these brands that Terry's talked about are brands we all use and engage with every day. So if we don't know this information, then how can we take the next step and ask these questions?
Well, please join me in a huge thanks to both Professor Chambers and Terry Collinsworth